Here's a jaw-dropping truth about child custody in Georgia. Your children can potentially decide their fate when it comes to which parent gets primary custody of them and their siblings. Did you know this? Stay with me as I explain this and tell you how to protect your relationship with your children. Before I even get into today's video though, I want to tell you that it's never a good idea to involve your children in adult matters and conversations such as divorce and child custody. In most cases, they're too young to have the context and experience in life to understand the ramifications of what's happening between their parents, and in all cases, it's a bad idea to use the kids as a tool for leverage or revenge against your spouse, and you could find yourself facing an action for child alienation if you do. I could talk for hours about this, but I don't have that time here, so I'll just leave it at that. Don't do anything that will screw up your kids and have them in therapy as adults trying to get over the damage that you did to them. So the short and skinny is that yes, under certain circumstances, a child can let the court know which parent they'd like to be their primary custodial parent, or in human speak, who they'd like to live with. This can happen during the initial divorce, and this can also happen down the road as part of an action for modification of child custody. Here's the way it works in very simplified terms. Under the age of 11, a child cannot have a say in these matters, period. But when the child is 11, 12, or 13, the child can express a preference for which parent they'd like to live with most of the time as their primary custodial parent. This is done by signing a specific legal document, and then that document gets submitted to the court. Now the court will still make the final determination, but the court may consider the wishes of the child. So to recap, when they're 11, 12, or 13, they can tell the court what they'd like, but the judge doesn't have to follow those wishes. Are you following that so far? Okay, now here comes the really interesting part and the potentially terrifying part. At the age of 14 or older, when a child files that document expressing their preference for which parent they'd like to have as their primary custodial parent, there is a presumption that the court will respect that child's wishes under the theory that by this age, the child should be allowed to make such self-determinations. It's a rebuttable presumption, however, meaning that it's not a done deal. The court still needs to approve it. In my experience, the court usually will do so unless that would be against the child's best interest to do so. So if the other parent is trying to prevent this election, they will have to show the court why it would be harmful for the child to be allowed to live with the parent whom they've elected to live with. Even with all that said, there's still a wide degree of latitude on how judges handle these elections to live with a particular parent, and the way this matter is handled varies from judge to judge, even in the same county. Some judges refuse to allow any minor child of any age to essentially tell them how to do their job, as they put it, while others will just keep that election in mind as they make their own decisions. And others will allow the child's choice to prevail unless it would be harmful to the child or unless they sense that the child has been bribed or coerced into signing the election. Some examples of where a child's election might not be in that child's best interest are as follows. The child might choose to live with a parent who's hardly ever home, allowing that child more freedom than they'd have with the other parent. So that can be harmful to the child depending on the situation and the involvement. Another one is that some parents may promise the child that they'll get a brand new car on their 16th birthday if they elect to live with them after the divorce or the modification, even going so far as telling that child that the money they will no longer have to pay for child support to the other parent can be used to save for that car. Now obviously that's bribery, it's emotional twisting, it's very harmful to the child. And some parents may tell a child that if they don't live with them, they won't get to see them very often at all, and that parent would be very sad if that happened. And that's emotional and mental abuse, coercion, and twisting. It is just horrible. So how do you prevent this kind of thing from happening? Well, there's two prongs to that answer. First, be very involved, be present and emotionally supportive of your children as much as you possibly can be, so if they won't want to live with the other parent if or when that document is put in front of them to sign. The best defense to the other parent messing with your child's mind and trying to twist them is to have a really strong bond with your child so that any such attempts will be fruitless. Secondly, document your involvement in your child's life with photos and videos and mark dates on calendars and that kind of thing. Why do I suggest this? Well, first, this creates something to look back on in years to come that helps you relive the wonderful times you had with your children. This is for them as well as for you. Second, you have the right to oppose the decision of the child in a court of law, so you want to make sure you can prove your involvement in the child's life and stop that election from going through. Now, many times these documents are put in front of the kids to sign, and the kids don't even realize what they're signing, so they aren't necessarily choosing the other parent. They may have been lying to that parent. So if you're going to fight that manipulation and try and protect your child's right to lots of time with you, you're going to need that evidence. The takeaway from this video and what I've explained is this. Yes, there is an opportunity for a child who's 11 years or older to express their wishes on custody, and even on parenting time with each parent. They may want to spend more time with you or more time with the other parent. And at 14, there is a presumption that the child can make that determination, but do not assume that you will be awarded primary physical custody just because your child signed the document saying that they want that. And don't assume that you won't get primary custody just because your child signed that document that was put in front of them by the other parent. The court will make the decision that they feel is in the best interest of the child. That is the standard that's going to govern everything that has to do with child custody. And by following my advice to build a really strong, loving bond with your child that could stand up to anyone, including the other parent, trying to screw with them and come between you two, you'll have the best shot at the custody outcome you want and the one that's most appropriate for you and your kids. Hey, thanks for watching this video. I hope you found it helpful. Be sure to click subscribe, like, follow, whatever's appropriate for the platform you're watching this on, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos with people you care about who need to see this information. Repost them. Let's get this information out to people who need to know. Also, leave us some comments. Let me know if you have questions or suggestions for other topics, and let me know your thoughts. I really want to hear what you have to say. Just keep it polite. Remember to join our Facebook group at Georgia Divorce and Custody and join in the discussion. And as always, I look forward to seeing you on the next video.